Hello everyone, welcome back to the English Law Channel. So I'm carrying on with the rights of mortgagees. So let's look at the right of foreclosure, and that's a judicial procedure. So a foreclosure order is issued by a court, and it vests the mortgagee's fee simple or leasehold reversion in the mortgagee, subject to prior mortgages as per sections 88.2 and 89.2 of the LPA 1925. But the request of anybody interested the court can order a sale as per section 91.2 of the LPA 1925. This is a provision which is there to protect the interests of the mortgagor and later mortgagees and accounts, partly because of the rareness of foreclosure orders today. So foreclosure is so unusual that, it's barely worth mentioning. It hardly exists in England and Wales. So the Law Commissioner suggested doing away with it altogether and replacing it with a broader mortgagee's power of sale. So then there's right to possession. So any legal mortgage has a term of years vested. Any mortgagee has a term of years vested in him, and he can go into possession as soon as the mortgage is made or before the ink is dry on the mortgage, as was said in Four Maids Limited against Dudley Marshall Properties Limited. That's 1957. Unless they've contracted out of that right, either expressly or impliedly. The courts are slow to imply a term which excludes this common law right, even though the mortgagor has been guilty of no default, and that's the only way in which the mortgagee can ensure the mortgage property is managed properly and the value of the security is maintained as per Western Bank Limited and Schindler 1977. Now, in reality, it's rare for a mortgagee to seek possession except as a preliminary to exercise his power of sale. So this is partly because he's a duty to account strictly to the mortgagor for any rents or profits that he's got, and as was said by a judge, on the footing of willful default, for all that he should have received, and that's as per White and City of London Brewery Company 1889. Now, naturally, there is a lower risk in taking possession if the property is already let to a tenant. In that case, the mortgagee takes possession and simply tells the tenant, pay your rent to me. But the court has a jurisdiction to stop such proceedings or slow them down. It'll only exercise them if then there's a reasonable prospect of the mortgagor paying off this or satisfying the mortgagee in a short time. There's a case about a Birmingham Citizens Permanent Building Society against Court 1962, or Mobile Oil Company Limited against Rawlinson 1982. Mortgagees are subject to a duty to use their right to possession bona fide, and they have to reasonably enforce for their security of payment that they're owed. But the limits of this duty, not its justification, are a matter of some debate, and there's not a lot about in the law reports. There's Quennell and Maltby 1979. Lord Denning sat on that one, or Lord Templeman in Cooperative Bank Limited against Phillips. Or Kuka-Rover Finance Limited International against Alpha Telecom Turkey 2013. The courts have the power to stay possession proceedings, and that's the only protection for commercial mortgagors. But the statute, Section 36 of the Administration of Justice Act 1970, or Section 88 of the Administration of Justice Act 1973, has intervened to protect the mortgagor of a home by giving the court powers to adjourn possession proceedings or to delay giving up possession for such a time as the court thinks necessary. So the court has to be content that the mortgagor is likely to be able to pay any sums within a reasonable period of time. Again, there's no definition of a reasonable amount of time. Pay any sums due under the mortgage or to remedy any other default. But the court's powers are exercisable even if there is no arrears or that there is no default, as per Western Bank Limited and Schindler. So in some cases, they've shown a great sympathy towards people who are borrowing to buy a house, like Cheltenham and Gloucester Building Society against Norgate 1996. The Court of Appeal allowed the whole remaining of the term of the mortgage, 13 years, for the mortgagor to sort himself out. That was extraordinary. And though cases have treated 2 years as a normal period to clear arrears, there's no length of time which is actually set as a reasonable period. So there's a common law right to possession, and the Court of Appeal looked into this at some length in Rope Gallock against Barclays Bank PLC. Here, the mortgagee didn't apply for a court order. They chose to use common law proceedings, and the court had no power to suspend the proceedings because Section 36 was inapplicable. But the mortgage has to relate to domestic premises, and if the mortgagor is in occupation and says no to possession, then criminal law obliges court proceedings to be taken by the mortgagee to get possession as per Section 66.1 of the Criminal Law Act 1977. Further, and this is quite contentious, Section 36 is disbarred where the mortgagee validly exercised the power of sale so as to overreach the mortgagor's equity of redemption without taking possession, and that's per Horsham Properties Group Limited against Clark 2008. Luckily, it seems that circumventing statutory jurisdiction like that, though contentious under human law, human rights law, is not something which happens very often. So there's also power to appoint a receiver. The mortgagee has the statutory power to appoint a receiver, and this power arises and can be exercised in the same situations as power of sale. And then this is very utile for the mortgagee wishes neither to realise the security nor to possess the property. The receiver, who's often regarded as an agent of the mortgagor, has a duty to manage the property and receive all the income from the property. So that's enough about mortgages.